Vaughn, since I've been on the air, it's been 11 minutes and 7 seconds. I've been hearing that there's something dramatic happening in the courtroom. Because I was wrapped by your report and Andrew's analysis, I don't know what it is. Bring us inside what's unfolding.
The courtroom was momentarily just cleared here of the gathered press as well as the jury because Judge Merchan wanted to admonish Robert Costello, the current witness brought forward by the defense team for Donald Trump. He has been limited to a very narrow scope of testimony that he has been allowed to provide, and there's been several instances where he has begun to answer a question, and then ultimately there was an objection raised by the prosecution, which was sustained by Judge Merchan. But from our team inside, they're saying that Costello at one point let out a geez, and then another time let out a sigh, and another point ordered something to be struck from the record. And this led ultimately Judge Merchan to order everybody out of the courtroom. And right before, as this was happening, there were some quick words that Judge Merchan directed at Costello, telling him to not roll your eyes at me.
Hey people, Jack here. Let me walk you through what happened. In a New York courtroom, Trump's witness Robert Costello was shut down by the judge after repeatedly editorializing and glaring with contempt, leading the judge to clear the courtroom and warn him that one more stare down would get his testimony struck. The moment illustrates how Trump's courtroom defiance meets judges willing to enforce their authority. And here's the thing that makes this even more significant. This wasn't an isolated incident. It's part of a pattern that's been playing out across multiple cases involving Trump and his associates. The same dynamic keeps emerging. Trump's team brings their usual political tactics into courtrooms: the intimidation, the theatrical performances, the refusal to accept rules they don't like. And judges keep shutting them down, sustaining objections, issuing contempt warnings, threatening to strike testimony, clearing courtrooms to deliver stern warnings.
He had suggested that he was, quote, staring him down. So it sounds like Robert Costello, who was that individual who was briefly counseling Michael Cohen for a couple months in 2018 and is testifying here that Cohen had told him that he did this all independently of Donald Trump, and he never informed Donald Trump of the Stormy Daniels payment. This is now sort of a key witness here for the defense team, but with the jury in the room, clearly Judge Merchan very peeved to the point that he asked the jury and the press to leave, and they are now just only being let back in.
Okay, so I have some of this transcript that Vaughn is just reading out to our audience. Merchan says, quote, I'd like to discuss, these are from our program's correspondent, Lisa Ferry, in the courtroom. I'd like to discuss proper decorum in my courtroom, Merchan says. If you don't like my ruling, you don't say geez. You don't say strike it because I'm the only one who can strike it from the record. Judge Merchan, you don't give me side eye and you don't roll your eyes. Costello, I understand. Merchan, clear the courtroom. This seems like...
Inside the legal system, Trump's normal approach doesn't work the same way it works in politics. And that's creating a fascinating and absolutely crucial dynamic that everyone needs to understand. Let me take you back to what actually happened with Robert Costello because the details are genuinely jaw-dropping. Costello was Trump's key defense witness in the hush money trial, someone the defense was counting on to undermine Michael Cohen's credibility and help create reasonable doubt. But from the moment Costello took the stand, he acted like he was at a campaign event rather than a legal proceeding. He tried to give long editorial answers that went way beyond what the questions asked. He kept talking even after objections were sustained. He treated the judge's rulings as suggestions rather than orders. And when Judge Juan Merchan kept sustaining prosecutors' objections...
This seems very theatrical. This seems very Trumpian. What sort of damage can it do in the eyes of the jury?
Can I just say, I have been in a situation where I have had to and gotten court permission to have a lawyer for somebody testify. Those lawyers are dispassionate and careful, and they are only going to answer questions that they legally have to answer because they have a continuing duty of loyalty to their client or sometimes former client. Mm-hmm. And and I would know in that situation that they were being completely ethical and trying to adhere to their continuing duties to their client. this is the antithesis of that from what we're seeing.
And just remind everybody who Costello is.
So Costello is somebody who Michael Cohen spoke to and had an attorney-client privileged relationship, but ultimately didn't hire. He has worked with Rudy Giuliani, and there has been evidence introduced, and this also came up in the Mueller investigation.
Doing exactly what judges are supposed to do when witnesses go off the rails, Costello responded with visible contempt. According to reporters in the courtroom, Costello sighed loudly into the microphone after objections were sustained. He muttered under his breath where everyone could hear. He rolled his eyes at the judge. He gave the judge what witnesses described as side-eye, a dismissive, contemptuous look that communicated exactly what he thought of the judge's authority. And most remarkably, he appeared to be trying to stare down Judge Merchan, a direct challenge to judicial authority that simply doesn't happen in normal courtroom proceedings. Witnesses don't challenge judges. They answer questions and follow rulings, but Costello apparently thought the rules didn't apply because he was there on behalf of Donald Trump.
Suggesting that he and others were part of an effort to try to get Michael Cohen not to cooperate. It'll be interesting to see how much that plays out on cross. His behavior in the courtroom, let's just say it is not consonant with what I have seen with somebody thinking about their obligations to that client or prospective client, and isn't coming off as dispassionate.
Yeah. I mean, Suzanne Craig, you've watched all of this. I've read it all, which is a distant second to seeing it. I've not read Merchan this upset in every day of the trial transcript that I've read.
No, and I think what's really important about it is how much the jury reads him. You always see in these trials I've sat through, this is my third one, and the jury and the judge have a real relationship. And I think this is it's a big error on Trump's team's part to have this sort of...
Judge Merchan's response was swift and dramatic. He ordered the courtroom cleared of all journalists, an extraordinary step that underscored how serious the situation had become. Then, with the room empty except for essential personnel, he addressed Costello directly with language that left no ambiguity about where things stood. He told Costello that his conduct was contemptuous right now and that he was putting him on notice. He warned that if Costello tried to stare him down one more time, he would remove him from the stand and strike his entire testimony.
Exchange happening in the courtroom. They really pick up on what the judge is thinking, and I think it works against whoever's doing this, which happens to be Trump in this instance.
It's so ironic that everybody was saying, oh, Michael's going to, be glib or bust or unravel. Yeah. 25 hours on the stand, nothing. This guy's on the stand for a half hour. So that tells you something. And Andrew, obviously, you know this infinitely better than any of us. That has to play on a jury. When you see a judge behaving that way, it destroys the credibility of that witness. I mean, it's just, he might as well say, don't believe this guy.
And they've got some smart jurors on there, including, but two lawyers, too, who, have seen this sort of thing before. They've been in courtrooms, I'm sure. They're going to be reading this.
I mean, judges like jurors. and jurors like judges.
Right.
Yeah. I mean, judges
they
are
need each other. That's the
they're like they're advocates.
Disrespecting a judge as a witness, it's just not a good thing. And especially because it's going to feed, the reason it's not helpful to Trump's team right now is that's going to feed into the cross.
Think about what the judge was threatening there. He was saying he would erase everything Costello had testified to. The defense's star witness would contribute nothing to the case. That's a nuclear option for a defense team that was counting on this witness to create doubt about the prosecution's case. And Merchan was ready to push the button if Costello continued treating the courtroom like a venue for Trump-style intimidation tactics. The judge also specifically called out the behaviors he wouldn't tolerate. He told Costello that he couldn't say certain things, couldn't give him side-eye, and couldn't roll his eyes. These might seem like small things, but they represent a direct challenge to judicial authority. When a witness sighs loudly and mutters insults after a judge's ruling, they're signaling that they don't accept the judge's authority. When they try to stare down a judge, they're attempting to intimidate someone who's supposed to be in control of the proceedings. Merchan was making absolutely clear that whatever works for Trump in political settings doesn't work in his courtroom. This wasn't even an isolated incident. In Trump's separate New York civil fraud trial, Judge Arthur Engoron faced similar problems when Trump himself took the stand. Trump kept trying to give long, rambling speech-like answers that went far beyond the actual questions. Engoron sustained objection after objection and repeatedly had to tell Trump to just answer the questions, no speeches. At one point, the judge called Trump a broken record because he kept reverting to the same political talking points instead of providing direct answers to legal questions. Two different judges in two different cases, both having to constantly shut down attempts by Trump and his allies to turn judicial proceedings into campaign events. This story matters right now because it demonstrates a pattern that's playing out across Trump's legal battles. He and his allies try to bring their usual political tactics into courtrooms: the intimidation, the theatrical performances, the refusal to accept rules they don't like. And judges keep shutting them down, sustaining objections, issuing contempt warnings, threatening to strike testimony, clearing courtrooms to deliver stern warnings. Inside the legal system, Trump's normal approach doesn't work the same way it works in politics. Let's break down what this means and where this confrontation is heading. To really understand the significance of these courtroom confrontations, we need to look at the pattern of behavior from Trump and his allies and how judges across multiple cases have responded. What we're seeing is a fundamental clash between Trump's approach to conflict, which involves intimidation, theatrical performance, and refusing to accept constraints, and the courtroom environment where judges have real power to enforce rules and where the usual Trump tactics don't produce the same results. Let's start with what happened with Robert Costello, because it's such a vivid illustration of how Trump's world collides with judicial reality. Costello is a lawyer who had dealings with Michael Cohen, and the defense called him to try to undermine Cohen's credibility as the key prosecution witness. In theory, this was a straightforward legal strategy: attack the credibility of the star witness and create reasonable doubt about his testimony. But Costello apparently came to court with the mindset that he was there to perform for Trump's benefit rather than to simply answer questions within the bounds of courtroom procedure. The problem started almost immediately when Costello began giving expansive answers that went beyond the scope of questions being asked. This is a common issue with witnesses who have agendas. They try to get their narrative into the record even when it's not responsive to what's being asked. Prosecutors objected, and Judge Merchant sustained the objections. This is completely normal courtroom procedure. When a witness goes beyond the question, the other side objects, and if the objection has merit, the judge sustains it, and the witness is supposed to confine their answer to what was actually asked. But Costello apparently didn't want to accept that framework. According to multiple reporters in the courtroom, Costello's reaction to having objections sustained against him was increasingly hostile and disrespectful. He sighed audibly into the microphone, a theatrical expression of exasperation that everyone could hear. He muttered insults loud enough for the courtroom to hear. He made dismissive comments when rulings went against him. These are not things witnesses do in normal proceedings. Witnesses who disagree with rulings keep it to themselves because they understand that judges have authority and that expressing contempt for that authority creates problems. But Costello was operating from a different playbook. The glaring and staring behavior that ultimately provoked Merchan's explosive response represents something even more serious than muttering and sighing. When a witness tries to stare down a judge, they're engaged in a direct challenge to judicial authority. They're saying through body language that they don't accept the judge's control over the proceedings. This is the kind of intimidation tactic that might work in political settings or business negotiations, but it has no place in a courtroom where the judge has actual power to sanction contemptuous behavior. Costello apparently thought he could intimidate Merchan into backing off. He was very wrong. Merchan's decision to clear the courtroom before addressing Costello was itself significant. Normally, judges handle witness problems on the record with everyone watching. By clearing the room, Merchan was signaling that the situation had escalated to a point where normal procedures weren't adequate. He needed to deliver a message to Costello without the circus atmosphere that cameras and reporters would create. When journalists were let back in after the recess, they learned what had happened. The judge had explicitly warned Costello that his conduct was contemptuous, and that continued defiance would result in his removal and the striking of all his testimony. The threat to strike testimony is a devastating sanction that Mershon was clearly prepared to use. If the defense's star witness gets thrown off the stand and all his testimony erased, the defense team has wasted their opportunity and lost whatever benefit Costello's appearance might have provided. That's not something any defense attorney wants to see happen, and it's a reflection of how badly Costello had damaged his own side's case through his contemptuous behavior. Mershon was essentially offering a choice: behave like a normal witness or lose everything you came here to accomplish. The specific behaviors Mershon called out might seem minor in isolation, but they add up to a pattern of disrespect that judges cannot tolerate. Courtrooms function on the basis of everyone accepting the judge's authority to control proceedings. When witnesses start editorializing and sighing and glaring, they're undermining that authority in ways that spread. If one witness can get away with it, others will try. If defendants and their allies can intimidate judges through hostile body language, the whole system of judicial control breaks down. Mershon was drawing a line not just for Costello, but for anyone who might think similar tactics would be tolerated. The parallel situation in Judge Engoron's civil fraud trial shows this wasn't a one-time problem with one witness. It's a pattern connected to Trump himself. When Trump took the stand in that case, he couldn't seem to help turning his testimony into a political speech. Questions that called for simple factual answers would prompt long discursive responses about how unfair the case was, how successful his businesses were, how persecuted he was by Democrats. Engoron had to constantly sustain objections and remind Trump to just answer the questions without the speeches. At one point, he called Trump a broken record because the pattern kept repeating no matter how many times the judge intervened. The broken record comment captures something important about Trump's relationship with courtroom procedures. He has a set of talking points and narratives that he deploys in every context: political rallies, media interviews, social media posts, and apparently witness testimony. The problem is that courtrooms don't work like those other venues. Witnesses are supposed to answer the specific questions asked, not deliver stump speeches about their general situation. Judges like Engoron, who enforce these rules, aren't doing anything unusual. They're doing exactly what judges are supposed to do. But Trump apparently experiences these normal constraints as persecution because he's not accustomed to anyone actually enforcing rules against him. The sustained objections across both trials reflect prosecutors doing their job of keeping testimony within proper bounds and judges doing their job of ruling on those objections fairly. When objection after objection gets sustained, it usually means the witness is repeatedly trying to go beyond what's appropriate. Trump's allies have tried to frame these sustained objections as evidence of judicial bias, claiming the judge is always siding with the prosecution. But that interpretation ignores the reality that objections were being sustained because the testimony was objectionable. If Costello had answered questions directly without editorializing, there would have been nothing to object to. If Trump had provided concise, factual responses instead of speeches, the objections wouldn't have been necessary. The contempt warnings that emerge from these confrontations connect to the broader pattern of judges threatening serious sanctions against Trump and his allies. Mershon's warning to Costello about contemptuous conduct mirrors his warnings to Trump about gag order violations. Engoron's threats of serious sanctions in the civil case followed the same pattern. Multiple judges are reaching the same conclusion that Trump and the people around him don't accept normal constraints and that escalating warnings are necessary to maintain courtroom order. This isn't bias. This is judges responding appropriately to defendants and witnesses who refuse to play by the rules everyone else follows. The clearing of the courtroom before Mershon delivered his contempt warning was covered extensively by media precisely because it was so unusual. Judges almost never take that step because they want proceedings to be public and transparent. When a judge decides the situation requires privacy to handle, it signals that something extraordinary is happening. Merchan apparently felt that delivering the warning with journalists watching would create a spectacle that would make the situation worse. By handling it privately, he could be direct with Costello without turning the moment into another chapter in the ongoing Trump media circus. The broader pattern here is judges discovering that normal procedures aren't always adequate when dealing with Trump's world. Regular witnesses don't need to be warned about staring down judges. Regular defendants don't need repeated reminders to answer questions without speeches. Regular trials don't feature contempt warnings and courtroom clearings and explicit threats to strike testimony. The Trump cases are different because Trump and his allies bring a different approach, one that treats confrontation and intimidation as normal tactics and that doesn't accept the legitimacy of constraints. Judges have had to adapt by being more explicit about rules, more aggressive about enforcement, and more willing to use sanctions that would rarely be necessary in typical cases. Let's bring this all together and talk about what these courtroom confrontations mean for Trump's legal situation, and for the broader question of whether he and his allies can ever accept the constraints that apply to everyone else in the legal system. What we've seen across multiple trials and multiple judges is a consistent pattern. Trump's team tries to bring their usual tactics into courtrooms. Judges shut them down with sustained objections and contempt warnings, and Trump's side reacts with outrage as if being subject to normal rules is somehow persecution. The Costello incident perfectly encapsulates this dynamic. Here was a witness who came to court apparently thinking he could perform rather than testify. When the judge sustained objections and enforced normal rules about answering questions directly, Costello responded with sighs and eye rolls and staring matches, the kind of contemptuous behavior that would get any other witness sanctioned immediately. Judge Merchan had to take the extraordinary step of clearing the courtroom and explicitly warning Costello that his conduct was contemptuous and that continued defiance would result in removal and the striking of all his testimony. A defense witness nearly destroyed his own side's case because he couldn't accept that courtroom rules applied to him. Trump's own testimony in the civil fraud trial showed the same fundamental problem. He couldn't stop giving speeches when judges and procedures required him to answer questions directly. He kept reverting to political talking points even when told repeatedly to just respond to what was asked. Judge Engoron had to sustain objection after objection and eventually resorted to calling Trump a broken record because nothing seemed to get through. A defendant who simply answered questions truthfully and concisely would have had a much easier time on the stand. But Trump apparently can't operate that way. Everything becomes a performance. Every moment becomes an opportunity for his usual rhetoric. The pattern of sustained objections across Trump's cases reflects reality, not bias. Objections get sustained when testimony is objectionable, when witnesses go beyond the questions, when answers include improper material, when courtroom rules are being violated. If Trump and his allies weren't constantly pushing boundaries and trying to turn testimony into speeches, there would be far fewer objections to sustain. Judges aren't manufacturing reasons to rule against Trump. They're responding to conduct that genuinely violates the norms that apply to everyone in legal proceedings. Here's what I think is really significant about these confrontations and why they matter beyond the specific cases. They demonstrate that Trump's usual tactics have limits. In political settings, Trump can intimidate opponents, dominate media coverage, and refuse to accept rules he doesn't like without immediate consequences. But courtrooms are different. Judges have actual power to enforce rules. Contempt findings and sanctions are real. Testimony can be struck. Witnesses can be removed. The confrontational approach that works for Trump elsewhere becomes counterproductive when applied to judges who won't be intimidated and who have the tools to respond to defiance. The contempt warnings that multiple judges have issued against Trump and his allies represent a consistent judicial conclusion that normal constraints aren't being respected. Merchan warning Costello about contemptuous conduct. Merchan warning Trump about gag order violations. Engoron threatening serious sanctions for attacks on court staff. Different judges, different cases, same conclusion that something about how Trump's side operates requires explicit warnings about consequences that would rarely need to be stated to other litigants. The common denominator isn't biased judges. It's a defendant and his allies who don't accept that rules apply to them. The threat to strike Costello's entire testimony if he didn't stop his contemptuous behavior shows how far judges are willing to go when pushed. That would have been a devastating blow to Trump's defense, their star witness contributing nothing because he couldn't control his attitude toward the judge. Merchan was prepared to impose that sanction if Costello continued. The only reason it didn't happen is that Costello apparently got the message and modified his behavior enough to avoid removal. But the willingness to go there shows that judges aren't bluffing when they issue these warnings. The political implications of these courtroom confrontations cut both ways. Trump's supporters see judges sustaining objections and issuing contempt warnings as evidence of the persecution narrative, proof that the system is rigged against him. But outside Trump's base, these incidents reinforce a different narrative, that Trump and his allies can't follow basic rules, that they treat every setting as an opportunity for confrontation and performance, and that they don't respect institutions that don't defer to them. The judge telling Costello that he couldn't say certain things or give him side-eye is a powerful image that undermines Trump's claim to be defending the rule of law. The question going forward is whether Trump and his allies can ever adapt to courtroom realities or whether they'll continue bringing their usual tactics into legal proceedings and facing the consequences. The evidence so far suggests adaptation is unlikely. Trump has been involved in litigation for decades and shows no sign of having learned how to be a normal litigant who follows rules and respects judicial authority. His allies, like Costello, apparently absorb the same approach and bring it into proceedings where it creates problems. The confrontational style is so deeply embedded that it emerges even when cooperation would serve their interests better. The clash between Trump's courtroom defiance and judicial authority is structural and ongoing. Courts will keep shutting him down, and he'll keep framing it as persecution, but the confrontation goes to the heart of whether anyone is above the law.